So I just wanted to do like a quick briefing or update on this whole Oxfordshire Council and Raise the Colours case, which actually it's the protest. In a way, the protesters aren't intelligent or descriptive when they're coming to explaining what they're doing, right? And it's a real problem connected to sort of modern law and how modern law is worded, which is causing people's immunities and protections to be overridden or discarded or ignored or doubted or denied, right? Because modern solicitors and lawyers want to argue and debate what our rights are and aren't with a judge, right? They want to argue what is reasonable or what is proportionate, and they get to decide. They get to put a strong argument in. All the lawyers and barristers and solicitors like to negotiate with the judge, right? They say, we're getting paid a hell of a lot of money to go in and negotiate. They're basically negotiators. They go in and negotiate with the judge, and if they can get the judge to agree with them, then we're allowed to have our rights. That's not how rights work. Rights are, you either have them or not. Nobody goes into the court to negotiate, whether sick notes exist or not, whether they exist in law. There might occasionally be a technicality around it, but the whole framework and model of it is not claimed to not exist. They don't argue. Usually, if you've got a doctor's document, it's usually accepted. Like if you give it to the probation office, or if you give it to the police, or if you go into a police station and you get a doctor's check, right? They don't argue that there isn't such a thing or the framework or whatever. It's rare, right? Unless you were injured by the police and you've got to prove negligence or prove what happened to you, or there's a technicality around the law, not the standard normal framework. What's happening with this whole political rights thing is the framework is being pretended that there isn't one anymore, that it suddenly ceased to exist, and all of the events, instances, incidents just fall under this law that you go into the courts and you prove a case, you have a trial, you negotiate, argue what the boundaries of your rights are, which is actually not the case when it comes down to mandatory procedure, and particularly jurisdictions that exist like Parliament, which they're trying to make out don't exist, right? And things that it covers, what it extends to, which are obvious and known, particularly when they make provision in law. In fact, the more and more they've started making provision in law for it, unless it is explicitly stated in law that it exists, they're trying to pretend that it doesn't, and I think that's the problem. Now, the case is Oxfordshire Council because they didn't want Raise the Colours putting these flags up everywhere, right? So Oxfordshire Council, Tim Bearder, got this lawyer, barrister, Robin Green, from Cornerstone barristers, right, Chambers, to represent in the High Court. Now, Oxfordshire Council didn't make an order themselves. That's important. Oxfordshire Council didn't vote or pass an order to try and stop anything being done, right? Because they can't. And that's important when it comes to this Noise and Statutory Nuisances Act 1993, which is just a act where the language and vocabulary in the act regarding political demonstrations, why was that enacted and why was it put into law? Not because nothing actually exists there at all. It was to help clarify the law, right? It's not that, if they hadn't put that into the law, there wouldn't have been a law. It's to help clarify, right? Codify in there, so to make sure it is recognised and applied. Very similarly to the control of advertisements, 2007, where they've got, in this section, you can use any act. And when it says you can use any act, literally, they're saying you can use any act, right? Any enactment, which that gives you direct, explicit use of the Bill of Rights. Now, there's something about these barristers which I'm very, very, very dubious about, which is like the language they're using. Look, Robin Green, KC, joint head of chambers, right? Now, there's a lot of these barristers are advising the government now. Rather than the government and Parliament just making a law themselves and, deciding MPs voting on policy in these committees, they're actually getting these lawyers in to advise them, and professors as well from universities. And it's almost like these barristers and lawyers are the ones who are enacting the law, because they're the ones who seem to be advising and telling the government what to do. They've got a massive influence over it. And the fact that, the Solicitor Regulation Authority won't act on any complaints about this subject at all whatsoever, it's almost like a unified consciousness. It's almost like by the time you've got the Crown Prosecution Service formed in 1985 and 1986, the Repeal of the Tumultuous Petitioning Act, which was a legal process to get requisitions and consent for petitions and privilege, right? By the time we get to the CPS, no prosecuting lawyers or barristers are facing contempt of Parliament or breach of privilege, none. And none of the police are. So that when there is a contempt or breach of privilege, no one's getting punished for it unless it happens literally inside Parliament, or if you blatantly interfere with, a committee or evidence, or someone giving evidence to a committee in their own investigations, not in our public petitions, which are also through standing orders, right? And now the private bills, there are only 1 to 2 private bills every session, hardly any. And there are only 6 or 7 parliamentary agents. But I've got a lot of sections on my website about this, right? And there was some mistakes in my case law table because after we'd done the original study, I asked Replit to scrape the whole work, and it started pulling other cases out which were only casually mentioned and putting them in the wrong context. So I've got to correct that table. That was just an AI error which I've got to correct. It's not that nothing exists, so there's no such thing. A lot of those cases are real existing cases. They just got misclassified in there, right? So I'm going to actually sort that out. But the other pages on my website are extremely accurate and very strong discussions on the subject. Now, I think that the unified consciousness of these, joint heads and these government advisors and the whole barrister sector is fighting against this. They want it to go away. They don't want the privilege of Parliament really to exist or to apply to petitioners or protesters or the public, right? They want to negotiate and argue what we are and are allowed not to do, and the judges like doing that, which is exactly what happened in this case, right? Although there was a case with Joyle and Morhan, I think it was a Good Law Project reported on it in the High Court, after this Raise the Colours, Oxfordshire Council, Robin Green case. It happened not long after it, actually. And this is the Supreme Court, I think, and even I don't think the Supreme Court should be allowed to make determinations on parliamentary cases where the original cause arises through Parliament and political discourse, right? But nevertheless, the Supreme Court decided that on private land, if someone blocks, access or a route, on private land, there's no case to answer because obviously it's political cause, right? Now that's a step forward, but it's not really a step forward because the Supreme Court were the ones who decided it, and the Supreme Court aren't meant to decide on matters like that. But, short of being a kick in the teeth, it was some sort of progress because supposedly if that legal case precedent is upheld, there shouldn't be any more cases around that. And if the CPS the Crown Prosecution Service vehemently tried to act against it, and they're the ones who were wrong all along. Although they did, when there was a Sadiq Khan, Mayor of London case with Stop the ULEZ, and people were protesting near his house, and he got them shut down, and they got arrested and prosecuted, and they lost. And then later on, the CPS offered no evidence, even after they'd been convicted, and then they were acquitted in the Crown Court. That was when the Sandeep Pankahara of H.P. Gower's law lost the case, and then it went to Peter Gotch KC, and they had their rights upheld, but it still didn't have their rights properly upheld and voiced as privilege of Parliament. They just call them rights, you know. And the CPS actually backed down, but then they all got arrested anyway later for a different offence and charge, which was conspiracy with criminal damage, right? So there's a lot of interplay going on. Sandeep Pankahara, by the way, ended up being made magistrate of Westminster after that incident, and Peter Gotch KC turns out to be a retired. He used to be a police officer for Thames Valley, right, in traffic law. And, you know, the prosecuting officer for Metropolitan Police was that Superintendent Paul Thomas or whatever. So I'm sure they both know each other, which was, you know, I wouldn't think it was fair or impartial to have ex-police officer, traffic police, defending a case, what was to do with protesting against, you know, all this APR and camera surveillance, which the police like and are heavily involved with and use, really, advocate. But anyway, so there's a lot of information there that I've just put. Going back to Robin Green, KC. So Robin Green, KC, he's approached by Oxfordshire Council Legal Services Department, right? And they definitely have not, well, they haven't made an order. The local council haven't made an order themselves or issued a fine through council powers, right? And that's important because they can't. There are acts like the Noise and Statutory Nuisance Act 1993, which says that councils can act against political causes, a political demonstration. Now, the word political demonstration only appears in the Act through the whole legislation. We've checked through it all, right? And we're confident that it only appears once in that Act. And there was an Act which it updates the previous 1990 Act, right? There is no occurrence of political protest. All other acts which mention protest, just call them protests, not political protests. You can have protests that aren't political and aren't matters and causes to Parliament, like, you know, an emergency at a music festival, everyone gets thrown off and protests against the police to get them let back on again. That's not a matter and cause to Parliament, but it's a protest, right? And this is where these solicitors like Robin Green and other solicitors, this is when we get into sort of, you know, the school of Professor Mark Elliott and his books, and, you know, Erasmus Professor John Baldwin and, you know, his whole career, where parliamentary privilege has been gradually kind of like, you know, hidden and tried to be omitted so that it's not really something that the public take up and use, or unless you've got an actual petition in your hand, not that you're just promoting the same cause of a petition or trying to raise awareness of it when it's the same matter and cause. And I think that's really the crux of the point around what this gravitates around, right? The Raise the Colours campaign it's not just nothing. It isn't kind of like an aimless pursuit. They've got their own name, right? Just like the Conservative Party or the Labour Party have their own name. Raise the Colours really is synonymous in this context, although it's not electoral, but as in a political identifier. It's like the Labour or Tories. Now, the Labour or Tories, whether or not you're an MP or a constituent or a petitioner, they have cases, and they have cases to Parliament. Not everything they do is cases to Parliament. Some's electoral or local council matters or work, but they bring cases. There are multiple cases they bring to get different acts put through Parliament, or causes and matters, and then us, the public, have got our grievances, right? Parliament is called to settle all grievances and for amending and strengthening the laws. Now, Raise the Colours, therefore, could actually be acting on under the prerogative of not just one cause to Parliament, but many. Now, one of the main causes they are raising awareness of and acting through and trying to get people to support, donate to, and sign petitions for is to deport, detain, identify, detect, deport and detain illegal immigrants, which is a live petition on the House of Commons collecting signatures. Then we know they're doing that because Ryan Bridge has been going around filming illegal immigrants. That's what he's actually doing. His whole campaign to get funds coming in, get the flags out, raise awareness of it, get people to look at his website, donate money. What's he actually doing with it? Well, he's going around getting evidence of illegal immigrants on boats coming in. He's detecting them and asking the government to deport them, right? And he's wanting the police to detain them. So he's actually engaged in casework, investigative work, and raising awareness of that matter. There's absolutely no doubt on this earth that that is what he's doing, right? And he chose to have the flag, the British flag, the St. George's flag, for what he wants to identify his campaign with and raise awareness of it, right? As well as they've got their own logo, right? And that is fact. And even this Judge Diaz, Mr. Justice Diaz, right, of the High Court, who heard this case between Oxfordshire Council and Ryan Bridge, and unknown persons, apparently, the rest of the people who support the cause or whatever, or might potentially support it, this is the thing. Now, Mr. Justice Diaz says that he's watched all the videos and he knows all about this, that he's been watching him, go around looking at illegal immigrants and boats and looking for evidence in these dinghies and things like that. So he knows what he's doing. And there are petitions about it, right? It is an existing cause and matter to Parliament, and Bridge is raising awareness of that. He's actually doing in detecting these criminals, and his videos are the evidence. He's in fact, judges are watching this evidence. Mr. Diaz he's a judge in a court, and he's looked at evidence. He's seen evidence of, illegal immigrants being detected. Now, this is the thing. That evidence is meant to be in Parliament to do something about it. The government, Diaz isn't going to make an order and say that the police will go down to the beach and arrest all the immigrants and seize all the boat's evidence and then get the army to go and form a line there and stop them coming in, because that judge can't make that order. Parliament can send the police there or get the army to go there or set up units and resources to implement it and do it. And that's what Raise the Colours are wanting to do. The videos of Ryan Bridge, right, are meant to be seen by MPs as well as promoting the cause to the public. It's meant to be looked at by his MP and other MPs, and people in Parliament who vote on it and make decisions so they can act on it. And also people who sign in the petition, right? He doesn't have to say the petition number all the time, right? It's abstract, and it's known, it's intuitive, it's obvious, right? That's what he's doing. Now, Diaz shouldn't have actually even been able to look at the videos of gathering evidence of illegal immigrants, because that's meant to be part of the presentation of the political case to Parliament, right? So that's one major fatal flaw in the case. Now, this is the problem. Oxfordshire Council didn't want them promoting the cause in and around Oxfordshire, but they didn't do anything themselves as an order. But their legal department, actually not properly understanding privilege, not believing in it, and being blatantly and vehemently opposed to privilege of Parliament, not wanting to help us prove our rights and strengthen the rights and help people be educated about them. They damn well, bloody well, are opposed to them and want to shut down everyone's rights. They're a threat to democracy, even a usurpation of rights. They're opponents of rights, and they're traitors of the Constitution as well. These people are traitors of the Constitution. I'm going to click on that page because I've shown you the joint head now. Joint head of chambers, which is, the Solicitors Regulation Authority are further joint heads. They're not going to do anything to these people, no matter how you word it, wrap it around their policy, rinse it out backwards, forwards, whatever. The bar standards and Solicitors Regulation are well in on this, and they're going to do everything they can to say, it's not a problem and we can't act in it, right? No matter what these barristers and solicitors do, short of headbutting you or kicking you in the testicles, right? They might do something if they spit on you, but if it comes to something that they're not legally supposed to or entitled to do, or lie or mislead a council or a court or the public, or that's that's they're not going to fight against their own side. They're just there to level. If someone rips you off out of money, maybe, or you pay them money and they don't turn up, right? If it's too obvious, right, but not when we get into corrupt practices, conspiracies, aiding and abetting, and undermining the Constitution, subverting the laws of the nation, right? Now, Oxfordshire Council have got this barrister, he's looked at it, he's taken the job on, he should have known, right? This is the thing. The administrative and constitutional law books do touch on this. They barely scratch the surface, but that's the whole point of supposedly being a high-paid barrister and having lots of time and money when you get paid to look into it properly, right? Which they haven't done. Professor Mark Elliott's books, which guide a lot of these people, are not sufficient. The criminal law schooling of, John Baldwin, Erasmus Professor John Baldwin, I don't know if I pronounced his name right earlier, Erasmus Professor John Baldwin haven't been teaching this. The Crown Prosecution Service don't want to admit it because all of this revolves around one thing. When these people bring these cases against political causes, when they bring prosecutions or civil challenges against a political case, it is a contempt and breach of privilege, and it's meant to be dealt with in Parliament. The 1840 Parliamentary Papers Act made a process whereby you could just get it stopped and no one had to go into Parliament because you just got it stopped with an affidavit. There's a lot of arguments around the interpretation of that act because people are obsessed with Stockdale Hansard. That's all what gets talked about and nothing else. And, the wording of the act it's to support and help the 1688 Bill of Rights, really, by giving an example of how you would claim such similar rights and privileges, right? I've got a very, very in-depth discussion about the meaning and interpretation of the Act, and I'm in due process with investigating it. I've been messed up a bit because AI makes mistakes, and there is some AI that, get things mixed up when it's doing tasks, right, which I've got to sort out. But there are cases on records. We need to get into the National Archives, into the Solicitor's Treasury, find all the speaker certificates and things like that. But at the moment, I'm going back through the journals again to try and consolidate the previous findings because we found some solid cases, but in the process of transferring it about back and forward, it's kind of got a bit unorganised, right, and mislabeled on some of them. But that's just an AI error problem. But there are some AI that is actually very good, just not when you leave it to itself and end up passing it from one AI to the other. Sometimes it gets a bit messed up. Now, coming back to this thing, right, before you do anything, you need to learn the whole history of privilege. You need to understand what it is, how it applies, who it applies to, and what it's for. And then you will look at all the legislation in a chronological order and see how they started enacting some provisions in to help codify some of it into law to make sure it gets enforced and make sure there's no doubt about it. It's not meant to be that there's a few provisions here and there in the law and that's all there is, and it doesn't actually there to further manifest and implement the underlying privilege, which is the law of Parliament, and it's a general spread of law, the 1688 Bill of Rights, and it applies to all actions and activity. It's a jurisdiction. You are bringing in a different jurisdiction, and you're saying this is under this jurisdiction. This is why you've got all these. This is why you've got all these, like the resolutions of Parliament 1980, and I think there was an earlier one as well about what things courts can look at journals and reports and things like that, but they can't determine any matters because they can look at reports and journals, right, to read them. They think they can make decisions on the actual matter and cause itself and the activities in casework when they can't. They're meant to determine when you've got a rights claim, like overriding objectives. They're meant to acknowledge that you've got a claim, right, and apply it. You're raising the jurisdiction. You're saying this what I'm doing is under this jurisdiction, and here's the evidence to prove that I have an existing case under that jurisdiction, and I want you to acknowledge and recognise it, not assess what I'm doing, right? And this is the problem, what happened with Ryan Bridge and all his, videos going around, not just the ones promoting the cause, but also collecting evidence, for the illegal immigrants, right? Now, there is an act called the Noise and Statutory Nuisance Act 1993, and in it, it's got the term a political demonstration. And it does not appear in any other act of law, that phrase. It identifies a political demonstration. So you can have a demonstration which is not political, right? This is a logic no-brainer. You can put this through AI. If you need to say it's a political demonstration to identify it, then if you're using the term a demonstration, is not a political one, right? Now, they didn't just pull this law out of nowhere, and there's no underlying basis, there's no underlying law, there's nothing. They just made this act, and then they just pulled it from nowhere and they said, right, they've got it next to the army and military. They've got a military or visiting forces, right? So it's on equal exemption to the military, the army, right? And they've got it, so if it's a political demonstration, the council cannot act in opposition and to bring any motion, and that's like, the councillors cannot vote against it or act, and the council executives can act against the political demonstration. Why? Oh, just because they've enacted it now in this act. And the military, actually, it's not. They already couldn't do it, but they're clarifying it in an act of law to make sure that it is completely and fully acknowledged. Now, no other acts of law have the term political demonstration or political protest. Now, if you need to attach political to a demonstration to exempt it, because a mere demonstration is not exempt, you surely need to attach political protest to a political protest as well. Surely, right? Now, all of the protest law is meant to be for the people just protesting over a random thing. Like, farmers want to get to the farm, but everyone went to Alton Towers and parked and they can't get past. So the farmers are going to block the end of the road off and stop them from going home, right? That is not a matter and cause to Parliament. It's a protest. Could be a spontaneous protest, right? These acts, you can search through them with the AI correctly, get a competent AI and do it properly and repeatedly, right? Let's not get this confused with if you kind of leave AI up to itself and it massacres things up, but you realise it's done it, then you've got to correct it all, right? All of the legislation which just says demonstration or protest is not enforceable on a political cause. It has to be political demonstration or political protest, right? And you don't even need those acts. Those acts aren't needed. The privilege of Parliament and parliamentary causes and matters can be applied to any act unless it says they can't be. You don't have to have it mentioned like in this particular act, right? In this particular act that we're talking about now, they mentioned it, okay? The Noise and the Statutory Nuisance Act 1993 with local councils, you don't have to mention that you can use a privilege to be able to use it or claim it in an act. But if it says you can't use it, that's when you can't. And that's what they did with the Tumultuous Petitioning Act, matters and causes to Parliament, and in some of the sedition acts, seditious meetings and things like that, when they were trying to cut down, but only ever on large groups. let's get this clear, right? They never, ever stopped one person or a small group of people from petitioning and having the privilege of Parliament in any act where it's needed. They only ever tried to cut down on large groups and uprisings, because of the Civil War, and that's where the only reason that the Seditious Meeting Act and Tumultuous Act were possible for larger groups. And then after, 1986, when they scrapped it all, there is no limitations. There aren't any limitations on privilege matters, right? And you can't even get done for sedition now because, they're all chanting out, Charles, they're all doing republic.org.uk petitions against Charles, right? That's actually more serious than any of these cases to do with, putting flags up or noise around or anything like that or blocking private property. And in fact, it's private property that's the questionable thing. In all of history, all these riot acts and, compensation and things, they allowed all these public actions and, incidents could arise, between opposite fractions and so forth, as long as they're not trying to overthrow the government. People weren't liable for costs in public, and it's taxpayer owned in public. Public's the place where the exemptions apply the strongest, and the privilege, because it's all taxpayer funded. And it was private land where it was more dubious and questionable, right? Like in civil tort and things like that, in the 1689 Claim of Right Act, protections for, civil debts, right? And if you owe someone a debt, which is, they put an end to it for MPs as well, using privilege to get out of debt. So that the private land is the more of the prominent argument. And that's why it's ironic and very, very strange why the High Court have gone and said, animal rebellion, don't have a case to answer on private land for blocking it, right? But yet, we've got this Robin Green KC and Tim Bearder from Oxfordshire Council and their legal team and Mr. Justice Diaz in the High Court have stopped them from putting flags up in public, right? Now, this is the basis, right? It is more stronger to have the right to do it in public when it's a parliamentary cause than on private land or property, and that's a fact. Now, that Noise and Statutory Nuisances Act, put this through a logic machine, please. Put this through any intelligence or logic known to mankind, right? If you had an act of law which put you on an equivalent exemption in a clause to what the army are allowed to have, the armed forces, and its purpose is to make it explicitly clear rather than not mention it at all and leave it dubious, right? And definitely doesn't say that you can't do it, right? They explicitly mention that you're exempt and you cannot be intervened in or shut down for making noise in public for a political demonstration. Why would they go out of their way to do that when they could just shut it down for something else which was equally as annoying as just putting flags up, which is a visual annoyance? And then you've got, flags on highways. Councillors you can have flags around and near highways because that's one of the powers of a councillor. There's a website, multiple websites that have a long list of things that councillors can do. One of them is to install flagpoles and flags on highways. It's a legitimate thing that's been deemed safe. Just like when they approved these big businesses putting these movie boards that would just distract everyone over the top of the motorway. Whenever you've got money now, it seems to be you're allowed to do it. Money's buying the right to do things that would otherwise be deemed unsafe or whatever. But the big businesses with money now are getting more things put through the council and government than what political protesters are getting about their own rights. It's like a privilege, a business privilege, loads of protesters go down the side of the highway waving flags, distracting motorists, so they get prosecuted and arrested. But, Coca-Cola applies to planning, gets a law put through and can put loads of screens down the highway selling Coca-Cola with flashing movie screens distracting everyone. It's allowed. They bought the privilege in law, and how did they get that law passed? And who lobbied for it? And why would the council approve it? It means that they're like, the council are putting the thumbs up and cheerleading all the private companies and saying, this is not dangerous or distracting. But then when Ryan Bridge comes along, they're saying it is because people don't like it. Well, we're opposing those people. So it's really hypocritical. There's it wouldn't serve a purpose. I don't know how Mr. Justice Diaz, right, wouldn't be able to get his head around this, or Robin Green KC, or Tim Bearder, right? Why would the law make certain in an enacted provision that make sure that if the army make noise or a political demonstration, we can't intervene and stop them because of that noise. But if they do something visually that people don't like flags, we can. So, but what would be the point? It would mean that they could be shut down. But the purpose of that other act is to make sure that the council can't take a side, intervene or shut it down, right? And there are other acts, like the Control of Advertisements, 2007, which is that if it's for a political purpose, you can use any enactment, which you use the Bill of Rights. Now, you don't need to use any enactment in the Bill of Rights under the Noise and Statutory Nuisance Act 1993 because they actually say that all and any political demonstration. You don't even have to say, hey, we enacted this law because a political demonstration about Parliament uses the 1688 Bill of Rights as a cause of matter to Parliament. We don't even need to acknowledge that act, let alone use it, because all we have to do is say, well, it's a political demonstration, just not a demonstration. They do it a slightly different way to the same result in the Town and Country Planning, Control of Advertisements, which is if you put an advert or fasten an advert up anywhere promoting something, unless it's an election advert, which has to be only up during a certain period of the election, then taken down, because election law is actually more strict because it's a competition, right? They're saying that, like, in Class F, you can use any enactment. Well, the enactment, it is an enactment. It's a valid one. It's in force. The 1688 Bill of Rights, right to petition, or in Scotland, the 1689 Claim of Right Act, right? That all prosecutions are illegal. It says you can use any act. That's an act that you would use, right? And nice for putting visual notices up. Now, the thing is that Control of Advertisements has got deemed and express consent. You don't need it, right? You don't need deemed and express consent, but it's just a gratuity. It's a gesture. Because when it says you can use any enactment, if you use a 1688 Bill of Rights, none of the act can apply. Because you can't be prosecuted at all or have an action brought. At all. So it defeats the point in the entire act as soon as you can use any act for what you're doing, right? And that is putting the flags up. But they're a patriotic symbol, but the patriotic symbol is being used to advertise and promote a cause of matter to Parliament because they've chosen it for that cause, right? And I really, you can't get hold of these people, right, to challenge them on it. They're so slippery unless you've got the money. Like, they don't want to speak to you on the phone. They haven't got any time for you. It's all money. Now, if you've got the money, right, get them in a courtroom or get into their barristers thing, right? They don't want to debate it with us. They don't want to talk about it with us. Although you can submit things to Joyle and Moore on a Good Law project, right? But whether it replies to you or not, you literally need to be like, literally have some kind of gender issue or, question about your legality in the country or something, you're about to be deported or some kind of severe environmental issue, right? This is a thing. Now, I don't know. I'm not saying Robin, I'm not trying to make out that he's not, intelligent, because he clearly is intelligent. And, we're talking about a hell of a lot of money with these people. But when you look at the textbook, when you look at the administrative and constitutional law books, they are vague on it. And when you look at what Professor Mark Elliott's teaching, and you assess it and his modules and the curriculum, etc., it isn't teaching people these areas of law. And then when you look at the parliamentary agents, there are only 1 to 2 people in all, 60, 70 million people in England. 1 to 2 people bringing private bills, and only 7 or 8 law firms, they're not on legal aid, who do parliamentary law. And they only do the private business. They used to do the public business back in the 1800s, but they've stopped doing it now. But it exists. Your MP's meant to help you. But none of these MPs have studied this area of law. You get the occasional barrister like, Simon Reevell or, Tony Vaughan. It's not their specialist area of law, right? They get interested in it when they get elected, right? Then people get voted into the Privileges Committee. They've got the past records and books, but I don't think they've got time to study them as much as everyone else. They're relying on the clerks and staff of Parliament to advise, what is the latest way of doing it. But even they are, they're opposed to these rights. I think they're opposed to them. They don't want us to have them or let us use them, right, when they clearly exist. So we've got problems. My main concern is this, right, with the way that these people are taught the law. If you've got to come into this from a pure parliamentary privilege entry point, you've got to know, understand, and want to learn about parliamentary privilege and its history and what it actually is. And then you've got to look at all of the acts which express parliamentary privilege, like the Tumultuous Petitioning Act, the Seditious Meeting Acts, the Parliamentary Papers Act, and then some other of these acts. They're only there to help clarify some things in situations where the matter might arise. Now, in this Noise and Statutory Nuisances Act, you might have a political demonstration. Why did they make a provision there? Because it's privileged. A political demonstration is privileged. You can have a demonstration which is not a political one, and it doesn't get the exemption, right? And you can have signs and notices under the Town and Country Planning Act 2007, which cannot use any act of law, because if it's not a matter in cost of Parliament, you won't be using the 1688 Bill of Rights. If it's a music festival and you want to get back on the festival for a hot dog, it's not a matter in cost of Parliament, right? Even if 10,000 people want a hot dog, right? It's a grievance between the promotion company or the venue and the customers, right? So, and that was like a bit like in the Combinations Act, they was trying to stop employees from opposing their employers instead of opposing Parliament, right? When it comes to wages and things like that. Employees versus the employer rather than employees versus Parliament and the law, right? So it's concerning that I actually don't believe that Robin Green KC, I don't think that he fully appreciates or understands the reasons why these scattered clauses through these acts exist, because I don't think he knows all these exact acts. I don't think he knows all of them and how they're all kind of like, because it's like a scad shrapnel of clauses, right? And even though the Public Order Acts, they never introduced the term political protest. When they repealed the Tumultuous Petitioning Act, they never did, and they haven't. They had political objects in the Public Order Act 1936 because of uniforms, right? But they didn't want people to wear uniforms to promote causes. And actually, it's interesting because 16th Century Rebellion wear a uniform, but that it's more to do with like militant groups like IRA and things like that, not people promoting a cause and matter to Parliament with a political object, just promoting it. or people defending yourself, because they don't want people wearing uniforms and posing as a military force, but you've got the right to bear arms to defend yourself, but not supposedly act as an organised military group to defend yourself, but act as, we're just a group of citizens doing a political cause. If the police are acting illegally against us, trying to force us off somewhere, we can defend that. But we're not trained, organised or uniformed, but we've got a legal right to defend and protect our cause, right? Which, I don't know how you'd achieve that if you didn't know what you were doing. But, that's what it is. So, the uniforms thing was banned and the Attorney General had to go check it out. But, so, and this is when we get to the Bankruptcy Act. The Bankruptcy Act is a very important act in all this scheme of things. But in the Act, it says you cannot use privilege of Parliament in this Act for criminal or civil matters. So it suggests that, why would you need that? If you can't use privilege for criminal matters anyway at all, why would you need that provision in the Act? Right? Criminal or civil. It denotes and it obviously makes it so that you can use it for criminal matters, and definitely when it's not in the Act, right? This is the thing. So I genuinely believe that, Robin Greencasey, he's not a retard. I'm not saying he's unintelligent, and I'm not saying he's stupid. But when it comes to these people, they've got their own side. They're doing it for the case, the suitcase, the money. They are brickwalling us. They're acting as a unified, the SRA, the bar standards, they're all linking arms together. And then, joint head, and these people are also advising the government. So these people who are denying us our rights and won't represent them are actually, they're advising the government as well. So I think it's an orchestrated plan. They've had an orchestrated plan to subvert and undermine our rights, and they're making a hell of a lot of money out of it, right? And even when Joy Lamorne comes along, right, and he's, doing this case in the Supreme Court, or reporting on it, whichever, I can't even remember. I feel embarrassed now because I should remember whether it was his case or not. I think it might have been his case. I'm not sure, right? But he reported it on his website. He did a big article about it, blocking the milk factory, wherever it was in Droitwich. I think it was Droitwich, or somewhere around there. Whichever milk factory it was, I think I've been past it and I know which one it is. I think I've driven past it I used to go past there quite a lot, right? I do know where it is. I actually know where the place is and which place it is. I've just forgot the name. I think it might be somewhere around Droitwich or something like that. It's somewhere in the sort of west side of England, right? Middle sort of west side, going towards sort of Wales or just a bit under it. It's around that sort of area, right? That case, there was no case to answer on private land. Why? It's because it's political or what, right? This is the thing. But in the High Court, the High Court can't hear it. So it's all about what the courts can and can't hear. But I think because of the whole judicial review model, and courts, you're allowed to criticise ministers and people in Parliament to do certain things, they've got this general idea that, because we can have a judicial review and because we can criticise, things that ministers might have done or whatever, that means that there's no... It's almost like they don't really think that there is a parliamentary privilege, unless literally it's, Lindsay Hoyle making an order, or them voting on an act of law, to vote it through the main act or whatever like that, or the committee, or like a select committee taking some evidence from you or whatever. They're doing it, not you by your petition, or not like, the general public gathering evidence on that matter and cause. Those things, the courts are intervening. But I think because the courts have been doing these judicial reviews, they don't think there's anything else left to protect or defend. They don't truly believe for the public that there is really a privilege or anything left, and they're totally wrong about that. They couldn't be more wrong, because it's a court of original cause. Grievances, Parliament is there to redress all grievances and amend and strengthen the laws, right? That's what it's there for. It's original jurisdiction, and courts can't interfere or intervene with it or look at the evidence. In my case, Watson, he was going through all my evidence. maybe I was stupid enough to submit it, but he was making decisions, determinations on it, which that's one thing that he can't do, right? I know now at that moment when I got asked, when I did submit my special rights claim and they give me a civil hearing, shouldn't have been a civil hearing. I should have said, excuse me, we need leave of, can we apply for leave of court to the House of Commons to John Bercow for Watson to hear my case. Excuse me, that's exactly that point in time in my case. That was I wish I'd have known what I know now, because that was like the magic moment, right? When I got my solicitor, she really didn't want to do it. She didn't want to put the rights claim in, but I made her do it. She went in there, she did what I told her. She entered the rights claim, and then DJ Fudge, she said, okay, this is a special rights claim. She said it's going to be a civil matter, not criminal matter, and it's going to be the other district judge who hears it, or do you want it to be heard in the Crown Court or the Magistrates Court, right? Now, at that point, she was offering me options, right? She was letting me decide and choose from a number of options and things. And it's at that point where I could have said, I'm sorry, my lady, my rights claim is parliamentary privilege because my petition campaign is a matter of cost of Parliament. The court needs leave from the House to hear and look at the evidence. Can we please apply to Mr. John Bercow for him to give leave, right? And that is a actual existing procedure and function. The other option would have been to come in with an affidavit through the 1840 Act and a copy of my petition, because it's a legislated procedure. There's a bit more arguing needs to be done around that, because it exists and it intervenes in criminal proceedings. But people, lawyers and historians, all they do is talk about Stockdale-Hansard and know the cases, and they don't talk about the meaning or wording or interpretation of the Act or the history. The meaning and interpretation of that Act is open to preliminary proceedings for Parliament and criminal prosecutions, right? And that's, you wouldn't have a skeleton argument. You wouldn't say, oh, I've got a skeleton argument, when you're having to prove a legal basis, you're not proving a legal basis with the 1840 Act, because it's a prescribed, explicit procedure which you fill this document A in with document B prescribed, lay them to the court. Is it real? Yes, it's published on Parliament's website, so it must be a real case. I didn't make it up, right? And this is my sworn statement that I was doing what I said I was doing. The judge agreed that he said that I was doing what I said I was doing anyway, right? Which is a big deal, because then I'm telling the truth, right? So I didn't have to prove that, because it was taken for truth, right? It was the truth. And that's prescribed. There is no skeleton argument. There is no trial. The proceedings are stayed by the court or judge, right? And I know now that the Act would be very useful when magistrates were turning up at public meetings and doing preliminary proceedings for things like private bills procedure and things like that. When, there's more than 20 people supporting a private bill, you still had to get permission and consents and so forth, right? You couldn't get prosecuted under the Tumultuous Petitioning Act or seditious meetings by a magistrate turning up at the meeting, because you could give an affidavit and a copy of the parliamentary paper to stay the proceedings, right? And actually, what you'd have done is, if it would have been someone might report your meeting and claim that it's not legitimate, that you didn't get a requisition or consent. So that's when you actually get out your order from the mayor or of a council, and an affidavit to swear that the 1840 Act is it's. This Stockdale-Hansard mentality is extremely retardant, and it's restricting intelligence, because there are all kinds of standing orders for preliminary proceedings, notices for preliminary proceedings through standing orders by order of the House, putting notices on church doors, putting notices in the newspaper, which is the Parliamentary Papers Act for newspapers, and notices as well, preliminary proceedings, handing the leaflets out. Some of those railway companies had pamphlets printed. I've got one on my shelf over there promoting a private bill. The printer printed it. It's by order of the House to be printed and distributed, right? You could get prosecuted for those, like getting people to support it. A magistrate, could come to a meeting and say, you know, this is illegal, right? It's sedition or whatever, or even, it's a tumultuous meeting, right? But if you get the affidavit out, or you probably would, the requisitionist would have a court order. But the person who requisitioned the private bill might not have been there, right? So if the person who'd requisitioned the private bill, right, or the petition, and it was like there was 500 people there, but they were the company staff who were assisting and aiding it, and he wasn't there, and he got on holiday, and he didn't actually have the order from the court on him, but they normally put them in the newspaper, right? These orders were published, right? A meeting was held by, the council and mayor, the corporation on the 5th, and it was decided, consented to a petition to Parliament, right? Everyone's going to know about it. The police, the judges, all the local people. If a justice came in and someone reported, they're having a meeting about a parliamentary matter, I don't think they've got permission, and they reported it, the magistrate could have gone there. It said the magistrate can shut the meeting down. Could have prosecuted them all there and then. If you got the newspaper out and the advertisement that said that the mayor's consented to and ordered that, this matter go to the House, that's your proof with the affidavit as well that you swear it's the truth because it was in the fucking newspaper, right? That would have stayed immediately. Anything commenced in any way whatsoever there and then, right? So that's an example of the 1840 Act. Going back to my thing in court, you're meant to use that. They need leave to talk about it or even hear it, and they never did get it. And I should have raised that up there and then. And I know that there's a video going around that people have shared of a guy who, this is like a random member of the public, right? He went into a court on a criminal charge and he said he wanted it heard at the Queen's Bench. And he actually got it, his case, and, apparently they stopped pursuing him, the CPS, right? I could have said that I wanted it heard in the High Court, right? But actually, you need leave. And that, the requirement for leave of court, right, from Parliament, for them to look at and hear the evidence, that is tied in then. There's a direct requirement to get a consent and consult with Parliament over it, and that is when you get into the standing orders of Parliament, a matter of grievance and privilege to the House, which is what it is, and that's why it's called petition for leave, because, here's a petition, we've got a court, they've got a matter, which they're claiming is a parliamentary matter, which they want to get permission and consent to hear it, but and what? The defendant claims that it's a breach of privilege, right? So, I should have been all over John Burkow at the time. I don't know whether he would have entertained it or not, but there's a lot of evidence now about all these procedures and rules, and it's, when you're on the spot, that's when you've got the brief chance, the brief flicker of opportunity to get it in. Because, if hell freezes over after they've made those judgments, that there's nothing that, Atlas can hold up the world, the oceans can tidal wave, the desert can burn, you can have earthquakes, you can have meteors crashing. Those stubborn magistrates' courts they'll break before they bend. And they won't even reopen it under the Magistrates' Court Act 1980, Section 142, when it's clearly obvious there was a defect in proceedings, right? They won't do it. They say, appeal. It's a contempt and breach of privilege. and you've had a crime committed against you by the judge, and they're meant to be summoned into Parliament and answer it, they're meant to be summoned by Parliament and answer in contempt. And that's what the journals are full of, these proceedings. I've got some recorded here. My CSV file got a bit messed up. I've got a kind of like... I've got to sort it out because the AI messed it up when it was actually in good order, only because it threw loads of other cases in that had collected. It thought it was helping me out, and it put a load in that it hadn't checked properly. So, but these are all concrete, solid precedents, and this is the thing. John Hatzel's book, Precedents and Proceedings. All of those House of Commons proceedings and orders that prove the jurisdiction and procedures are legal case precedents of a high court, right? Not the Supreme Court, or the High Court of Parliament. But yet, they're still singing with their fingers in their ears, and they blatantly refuse to do anything about it. And I don't know, even Gerald Morgan doesn't seem to be, this Robin Green KC case is absolutely ridiculous because it's blatantly obvious. We know that Ryan Bridge and Raise the Colours are doing a campaign to deport, detain and detect illegal immigrants and wanting the government to do something about it. They've called themselves Raise the Colours. They've got active petitions. The petition is not Raise the Colours just as much as the Labour Party is not private members' bill from a Labour Party member, right? Raise the Colours can be acting on various causes. It's like saying Robin Green, Casey and, Cornerstone, Barristers' Chambers aren't the Oxfordshire Council case, right? Raise the Colours are acting on detain, deport and detect illegal immigrants, right? So... this is it. Something needs to be done about it. We need to complain to the local council ombudsman against Oxfordshire Council. The local authorities ombudsman needs to be contacted, and the SRA, but they're not going to do anything against Robin Green. It doesn't matter. You could get Wordsworth to do it. There's the terms, the way they've wrote that policy, their terms, their vocabulary terms, they don't want to do it. They just want, if Robin Green Casey spat on someone or need them in the bollocks or, they delivered him a suitcase for £20 million, then he just flew to America and didn't turn up in court, they'd do something, right? But when he's undermining, I don't know if he's knowingly doing it, but he should know better. He shouldn't have took the case on, right? I think that he should know better. And Oxfordshire Council Legal Services do. And this ties into the Parliamentary Papers Act when you use it, when you've got civil matters, when you're opposing the council or a council decision, and you've got a petition to Parliament over that matter and cause, or touching on that matter and cause, like protecting a scheduled monument. And that's also meant to stay the civil proceedings as well, and the council blatantly refusing at Kirklees with mine, right? And that's another matter. It's the same sort of matter. It's the same jurisdiction. It's the same privilege. It's just the difference between civil and criminal, right? And the SRA will not do anything about it. I've threatened the woman who's in charge of it now. The SRA is a scam, and so is the Bar Standards. They're scammers. They're paid for by the legal community. All the funding comes from the legal community. It's like Robin KC, joint head of chambers, and his pals have put a group together to police themselves. It's like their own pals and buddies are, going to keep watch over the whole legal sector, right? And they're definitely not going to pull the whole legal sector for completely undermining and subverting the laws of England, since at least the CPS was invented and before. Because that means that they're all in trouble and they've all done something wrong. They're going to vehemently defend themselves and their colleagues, and they're even advising the government on it. Now, if that's not... he's saying, joint head, talk about these joint heads, right? Put a few heads together. They're all brick walling us in a unified brick wall. They're not going to do anything about it, and they're going to continue to do it while they can get away with it, right? That's what they're going to do. And, you know, they're meant to be in a very high-paid position. They're on a lot of money. They're meant to be educated. They're meant to be studying and reading these laws and learning something. They're obstructing our rights and they're helping the councils, the rebel councils, subvert and undermine the rights. And Tim Bearder is a traitor to England. Tim Bearder is a traitor to the country and the Constitution, and he's a traitor to fact and reason. And the fact that it's Oxfordshire Council, they've got Oxford University there. You know, they've got at least 2 MPs from Oxfordshire area. They've even got members of the House of Lords, you know, North Oxfordshire or whatever. And then the Lords aren't going to do anything because, you know, they've been, you know, Lord Toby's been knocking out his free speech union. When it's political speech, there's no doubt or question about it. It should be privileged, right? But they've been pulling in political speech cases and using their donation money to help try and make out that there's no such privilege on free political speech either, right? You know? Although there is some questions about, you know, respect to dignity and decency, you know? But that's going to be dealt with by Parliament, not the other courts, right? You know, with Starmer and things like that. Particularly with these political parodies, but they've always let the newspapers do political parodies, right? You know, it's like a flagship thing, you know, newspapers and political parodies. I'm not happy with Robin Green, Casey, at all on Mr. Justice Diaz. I've actually submitted one of those affidavits because it's actually, the thing with the flags is there's quite a lot of bills on flags and the English flag and St. George's flags, and they're part of parliamentary papers and reports in a way. And there's a really crazy spin-off with the flags that the actual flag itself is part of documented and published proceedings of Parliament. So in a way, you can't really stop them putting the... Well, they can't stop the Speaker. Mr. Justice Diaz wouldn't be able to stop the Speaker or MPs, or if the MPs got a group of people putting a flag up around Westminster, and then you say, well, what happens if they do a march and procession from London to Glasgow and go through Oxford? Can they shut that down? Probably not. And this is when you've got, you know, can they even bring an injunction? I doubt it. I don't think so. I don't think that if Speaker Lindsay and the MPs of Parliament put flags up outside Parliament, Diaz could not injunction it. And I severely doubt that Tim Bearder could get Oxfordshire Council to they wouldn't do it. If it was like, you know, Siam Berry, you know, and like, you know, the Green Party or something, doing green flags, and they did a walk from Parliament and the Speaker launched it off, and then they walked all the way through the country with their flags to Oxfordshire up to Scotland, they would not shut it down, even if they fastened them up in public. I think you would get them enforcing that that parliamentary provision, in that parliamentary rule of no injunctions. You can't be injunctioned by the courts, but they've been doing it, and they want to do they want the future of England to be that a suitcase full of money and a negotiator, like the negotiator, right, get to sit down, put their feet up, take their shoes and socks off, you know, to take their shoes up, go into the court, and Robin Green KC with his suitcase of money wants to go into a court and have a nice cup of coffee with Mr. Diaz in his chambers beforehand, and they get to discuss and decide, negotiate, weigh up and determine what our rights are and aren't, and what they apply to and don't, and what's proportionate or not, what's reasonable in what these people are doing, when actually it's not in the jurisdiction of the court to look at the freaking evidence, because Ryan Bridge was filming illegal boats, which is evidence to the government or whoever watches them. I'm sure they're actively in contact with their MPs and Parliament on the findings of that evidence, right? on all the illegal boats coming over. That's what it is, right? You can't get these people in a room and pin them down. Tim Bearder is a traitor to England. The fact that he would even conceive of trying to pull it off, let alone going to the High Court. Ryan Bridge, he doesn't study the law. He doesn't know the law. He didn't pay for one of these barristers to defend him. He went in by himself, right? I think the Parliamentary Papers Act 1840 is perfectly adequate for use here for proceedings, or if not blatantly, he should have said, have you got leave of court to hear my case? We're detaining, and, we're investigating for detaining, detecting, and deporting illegal immigrants. You know that, right? You sort of leave of Parliament, or even, but we're not, even when you petition Parliament with a grievance, they're not doing anything. The staff won't help us. We're being abandoned. We're abandoned by the staff. Even big businesses, because big businesses don't need to do private bills anymore. Now, this is the thing. They've got all the big businesses, right, get provisions put in the acts. And, like for these, whatever they are, they've got provisions in the acts for scheduled monuments, That's why you can apply for a certificate in Scotland or Wales to protect a scheduled monument. You can petition for the protection. In England, it's going to be like a future claim of future interest. But the councils are even applying those clauses in the legislation which they've got, so you don't have to bring a private bill or petition Parliament. And that's where it's failing. And that's where it comes in with these acts as well. Now, the Town and Country Planning Act 2007, you don't need to petition Parliament on a grievance because it says you can use any act blatantly, so you can clearly use the 1688 Bill of Rights. And if it's a political demonstration, right, not only making noise but using flags, how can you be prosecuted when you've been given equal status to the freaking army, right? And this is the thing for the Noise and the Statutory Nuisances Act 1993, right? They made it easy. You don't have to do a private bill to Parliament or a public business petition or even grievance them if you were making noise, because it clearly says if it's a political demonstration. Now, the only way they could do anything is if they blatantly and stubbornly refuse to acknowledge it as a political demonstration, right? If they just said, oh, it's just a demonstration, like, some people trying to get back into the O2 Arena to hear a gig when there was something happened, like, I don't know, like, there was something wrong with the lights or something and no one could see, like, the lights went off and it was dangerous and everyone got chucked out, but everyone protested to go back on again. It's a demonstration. It's not a political one, right? Now, you got to identify it as a political demonstration. Now, this is the thing with Bearder, right? Bearder and Oxfordshire Council Legal Services they know it's a political cause, raise the colours, because they didn't make an order from the council. They couldn't. So they've gone to the High Court and they've tried to get an injunction from a High Court when even they themselves can't do anything, when they know that they're not meant to be opposing it personally or acting against it as people in those job positions, like the council employment policy is, impartiality. I will not give for any other cause or whatever, right? Supposedly, which I don't know how you can have a Labour Party, but that's supposedly what it is. You have to be, selfless. It's called a selflessness policy, right? So I really don't know what planet Diaz and Green are on. They're on like a planet called Suitcase 10B, right? It's like, can I get a star named after myself, right? Can I get a suitcase named after myself? Suitcase, 10 billion, right? They're living in the world of suitcases and money, right? Wads of cash in suitcases buys you what you want because you're ignorant and stupid. And Tim Bearder bloody well wants to oppose that campaign. He doesn't like it, and it doesn't matter whether the public like it or not, right? Everyone's got a legal right to bring a matter and cause to Parliament, and if they want to oppose that cause, they do it through their own campaign, right? And you're not meant to intervene in or obstruct other campaigns because that's contempt of Parliament, right? And that's within that jurisdiction. You might say, well, what's the point? Well, the point is it's other courts, like the police and other local courts and matters. And that's why Tim Bearder really, he didn't go to the magistrates' court, like enforcing a fine or anything like that. He's gone to the High Court, because High Court currently is a scam. And after the whole Good Law Project incident with this, milk factory, wherever it was, in Droitwich or wherever it was, right? And this blocking on private land, they've stabbed us in the back because it's the other way around. It is and was protected in public, which is why those provision and clauses even exist, to help clarify that when there might be a political demonstration, when there's some noise, or putting out signs and notices through the Town and Country Planning Act, right? And that's where there's something really, really, really wrong with council legal services staff. And it's also in our local matter with that scheduled monument, right? We've had a debate with AI that it would be pointless if anyone with the right of occupation of a site could have an interest in future ownership. There would be no point at all having an interest in future ownership if it only applied to the person who already owned it or their relatives, because it would only apply to literally a handful of people. And that's nothing like the Scotland clause, which is that anyone can apply for that protection certificate in Scotland or Wales. So the English clause to protect a monument would have to be something similar, which means, anyone who's got an interest in it should be able to raise that interest rather than not on the person who's... Why would the person who already owns it or a member of their family, right, who might inherit it, raise an interest in future ownership? It's not logical. It doesn't make sense. It doesn't make sense at all. So, and I know that the legal services staff in local councils like Kirklees and Oxfordshire are working on the same intelligence and initiative as Robin Green, and they're traitors. Robin Green has gone into a court, he took the case, he took the money, and he argued it, and they've gone and, talked Ryan Bridge into agreeing to this undertaking, right? When his campaign and cause actually it's privileged. You don't. The thing they've done with that, that Local Noise and Nuisance Act, the Noise and Statutory Nuisances Act 1993, you don't have to prove that you've got a cause of matter to Parliament or that there's any special privilege or even show a petition. The qualifying factor literally comes down to the fact between, is it a demonstration or a political demonstration? As soon as it's identified as political in nature, they're giving you exemption, which is the privilege, just by identifying it as political. They don't do that in the Town and Country Planning Act 2007. They say that in Class F, you can use any act. Well, why would you want to use any act, and what acts are there? There are lots of different situations where you could be using particular acts of law, like putting notices up which are required. The thing with petitioning is this: the private bills, standing orders, were very, very, very important to follow. And they prescribed all these strict rules that you had to put notices. They're making you put notices by order of the House. They're making you put notices. You don't have the option to. It'd be better if private bills didn't have to put notices, because then they didn't have to notify people, and then people don't oppose it, right? They're trying to. The public petitions fell from the tens of thousands in the early 1900s, and after the telephone was invented, dropped down to less than 100 some sessions, right? Public petitioning had nearly dropped off the map, and the private bills now has nearly dropped off the map. What does that leave? What's Parliament even for if not for private bills, private business or public business?